Good afternoon, Your Honours. This is case number IT 9623/2I, the prosecutor versus Dragan Zelenović.
Thank you, Mr. Registrar. Mr. Zelenović, I take it you're Mr. Zelenović. Can you hear me in a language you understand?
Da.
Yes.
Then I'd like to have the appearances prosecution first.
Good afternoon, Your Honor. I'm Hildegard Urzretzlaff. I appear for the prosecution together with case manager Sebastian van Hooijdonk.
Thank you, Madam Urzretzlaff. And for the defense?
Good afternoon, Your Honor. Charter van der Spoel, duty counsel.
Yes. Mr. van der Spoel. Mr. Zelenović, I take it that you discussed with counsel the purpose of the proceedings today. That is, you make your first appearance before this tribunal, and later on you'll be invited to tell us whether you consider yourself guilty or not guilty. That's the main purpose of this hearing. And then if there are any other issues as far as detention is concerned, about your health is concerned, you could raise them after we have done this. Mr. Zelenović, one of the first things I have to verify is that you are represented. And I do see that Mr. van der Spoel is with you today, and he just, when saying that he was duty counsel, we understood this, that he has been appointed by the registrar to be duty counsel today. Do you want to say anything about your representation by Mr. van der Spoel today?
No.
No. Normal.
Have you received the indictment in your own language?
Da.
Yes.
Yes. Do you understand the content of the indictment? There must be something. Did you understand the content of the indictment?
Potpuno ne razumijem.
Yes, I have fully understood it.
Yes, there was some interference. Mr. Zelenović, you have the right to have the whole indictment read out in full to you. Do you want to exercise that right, or do you want to waive this right? If you want to exercise that right, I'll ask the registrar to read aloud each count of the indictment.
No.
Then we'll come later to the several counts of the indictment. By the way, you don't have to keep standing all the time. If you'd rather sit down, which is more comfortable to you, because it will take some time, please then be seated. Mr. Zelenović, pursuant to Rule 62A III of the Rules of Procedure and Evidence, you have the right to enter a plea of guilty or a plea of not guilty on each count today, but you also may choose to enter such a plea within 30 days of this initial appearance. I don't know whether you discussed this with counsel and whether you decided whether you'd like to enter a plea today or whether you'd rather wait until a later moment within 30 days. What is your choice? Well, there's no need for every single answer to stand up. That's
Ja sam odlučio
I have decided to plead in 1 month's time. I have not got a counsel. I haven't consulted counsel, so I'm not ready to plead today.
then yes, so you take your time. We'll then schedule another hearing in which you'll be given an opportunity to enter a plea. Therefore, we don't have to go through all the counts of the indictment at this moment. You have delayed the plea. Mr. Zelenović, there are a few other matters then which I'd like to raise. First of all, I'd like to inform you that the prosecution in this case has filed a request before the referral bench, which is a chamber of 3 judges, a bench of 3 judges, asking that these judges decide that your case will be referred to the authorities of Bosnia and Herzegovina. So asking that this tribunal will decide that finally you'll have to stand trial in Bosnia and Herzegovina rather than in The Hague. I just wanted to inform you about that so that you do not live here with the expectation that your case will be heard anyway by this tribunal. Another matter I have to raise is your pretrial custody. Upon your initial appearance, your custody is ordered. You'll be in pretrial detention, but you may file an application for provisional release pursuant to Rule 65 of the Rules of Procedure and Evidence of this tribunal. And if you'd like to file such a request, then standby counsel will be able to assist you in this matter. Another matter I'd like to briefly raise is that within 30 days of this initial appearance, the prosecution will disclose to the defense all the material that supports the indictment against you that will be sent to counsel. But it will also be disclosed to your counsel in your own language. That means that you can read it. It will be in your language, therefore, as well. Further, but this is mainly addressing Mr. van der Spoel, your counsel will have an opportunity to file within a 30-day period of time any preliminary motions, at least on from the date when this supporting material to the indictment has been disclosed to him. You're still standing. As far as I'm concerned, you may be seated, Mr. Zelenović. There's Mr. Zelenović, I'll now ask your counsel and the prosecution, having heard that a plea will not be entered today, if there's any other matter the prosecution would like to raise at this hearing.
Honor, just an information, we actually were prepared to provide the supporting material today, but because we have only here today the duty council and not the permanent council, we thought it better to wait until we have the name of the permanent council. It's much more practical to disclose it once to this council.
Yes, isn't it right that the rules in respect of the time limits for the filing of preliminary motions have been recently changed, only a couple of weeks ago, and that the disclosure obligations remain, but that the 30-day period of time, that's at least what is in the back of my mind, waits, it does not start until duty council is replaced by permanent council, or at least other council. This has the advantage, Madam Hertzog, that the accused can already start reading the material. So therefore, I don't know whether there's any need to delay the disclosure, even if duty council would not immediately start acting on it in full detail. But at least then the disclosure is there. I see, Mr. van der Spul, you're looking in the rules. I think, as a matter of fact, that these, I don't even know, I have to be careful because I think the amended rule enters into force, I think 8 days after it has been published or something like that. But there is something in the back of my mind which says that there might be. Or am I mistaken? It's still possible.
I'm actually not aware of this change, but Mr.
It
van
was-
Hooydonk
if there's
is looking for it at the moment, but
If the change is there, it's the most recent one. So that's from last month.
we will definitely check it and we
Yes, and
disclose as
perhaps
to-
I mixed up a few things, but therefore
But we
I do not-
definitely have the material together and we
Yes,
disclose.
I think as a matter of fact, nothing opposes against disclosing it, even if duty council would not immediately start working with it, at least, and that's the understanding, that the time limits for filing preliminary motions would then start at the appropriate moment.
May I remark on that, please, Your Honor?
Abigman.
May I remark on your observation,
Yes.
please? I discussed the matter yesterday with my client, and he was very clear in his position. He thanked me very much for explaining what the proceedings are, but everything concerning his case he would like to have done by his chosen counsel in Bosnia and Herzegovina. He has mentioned the name of the counsel to the registrar. The counsel is not yet on the list of defense counsel for the ICTY, but could be put on the list. It has to be assessed. We're doing the anyway, the registry is doing the process now, and in the meantime, I have been instructed not to do anything. I have discussed the provisional release with my client. Of course, I have discussed the disclosure. The rules I have are the rules of the 29th of March 2006. Perhaps there are more recent rules.
No, that should be them, and otherwise I might.
But just to be sure, I don't want my client to be put in the position that I have to do something that he doesn't want me to do. So
No,
I
but-
think it is a sensible suggestion from the side of the prosecutor to
Yes.
disclose as late as possible that the
Yes.
chosen counsel have more time to prepare his case and to see if he can file an objection against the indictment and things like that.
Yes, I think as a matter of fact that the time should remain the same for chosen counsel. It's only that Mr. Zelenović would deprive himself from an early reading of this material. That's the only thing I had on my mind, which that might interest him. Mr. Zelenović, if the material will be later disclosed to a counsel of choice, then it would also mean that you could not read it yet in your own language. If you'd say, no, I would rather start reading, even if Mr. van der Spul doesn't read at the same time the English version, then please tell us so that we can see whether it could be resolved in such a way that you do not deprive yourself from looking at the material, and that it would not negatively impact on your possibilities to file preliminary motions.
Mene u sudu u Sarajevu predstavio advokati.
Counsel is representing me in court, and he told me I shall be representing you. If you take a lawyer in The Hague, then the lawyer won't go to Sarajevo to defend you. So I suggest that I be your defense counsel, because your case will probably come up in Sarajevo, whereas the Sarajevo counsel would not be representing you. That is why I handed everything over to that particular counsel, and he told me not to say anything without consulting him. I gave the visiting card of the duty counsel to this other counsel so that they can get in touch.
Yes, well, perhaps, Mr. van der Spoel, you'll be able to communicate this specific matter with counsel Mr. Zelenović has chosen. By the way, Mr. Zelenović, does counsel of your choice, does he speak any English or French, as far as you know?
Meni su u Sarajevu dali spisak.
In Sarajevo, they provided me with a list of lawyers, and I selected that particular person, but I didn't ask him. I have his visiting card, and I handed over the lawyer's visiting card to the duty counsel, so he is informed of the name and the telephone number and the details.
Because that could cause some problems in having him assigned to you, even if it were only for the 11 bis proceedings, because it's uncertain whether the 11 bis proceedings will go quicker than the development of the proceedings in the case against you. But that's perhaps something to, Mr. van der Spoel, to the extent possible for you to discuss with counsel of choice. Then when you refer to March, that was the date of publication in March. I take it that the rules have been...
That's correct.
Yes, I take it that there have been amendments to the rules after that. But whenever I find something, I'll make it clear to the parties that every rule is available to everyone. Madam, I've got a few questions. First of all, the operative indictment at this moment is an indictment which still bears 3 names, although I'm aware that the names of 2 co-accused since then have been in a separate indictment. It seems that the cases of them have been severed, but are still on the operative indictment.
Yes, Your Honor, that's our understanding.
Yes, and is this how you'd like to keep it, or?
Yes, Your Honor, we didn't actually intend to amend it.
I beg your pardon, you did not?
We did not intend to amend it.
No, you did, however, for the 2 others. I think they have got their own indictments, to say
that's
that.
correct, but we actually, the first one against Mr. Stanković was amended because the charges were changed.
Yes.
And in relation to Mr. Janković, I seem to recall there was a challenge against the form of the indictment, and that's why we amended it. But I may be mistaken.
Yes, but they were then also separate indictments. But
Yes.
Mr. Zelenović will be accompanied by 2 co-accused who are not appearing anymore in this case.
What actually can be done, reductions can be made without having an impact on the indictment as such.
Yes.
That's also done occasionally, but that's not really considered an amendment. It's just reductions.
Yes, well, that's... then I have one other question for you, because within the next 30 days we'll hear a plea entered by Mr. Zelenović, I take it. And I have one question which is not where the indictment perhaps needs some interpretation in order to be fully understood. Whereas I think that I'd like to understand what the indictment against the accused is, and I take it that the accused would like to know what the indictment against him is. I'm taking you to page 5 of the amended indictment. In paragraph 5.3, we find a description of soldiers, among them Mr. Dragan Zelenović, interrogating the women that were detained, then threats expressed against these women, and then it continues that these soldiers, Dragan Zelenović being among them, gang raped several women during or immediately after the interrogation when they suspected of who they suspected of lying. And then it says that in paragraphs 5.4 to 5.6, particularities of some of those assaults are given. And then we find in 5.4, we find what happened to a witness codenamed FWS 75. And then it says that she was interrogated, also by Dragan Zelenović. But when it comes a few lines further down, when it comes to rape, it says that she was raped by 10 unidentified soldiers. Whereas it seems that in 5.3, you identified Dragan Zelenović as, at least that's, I have some difficulties in understanding it differently. But in 5.4, we find none of the persons suspected of having raped witness FWS 75 as being identified.
Your Honor, what we believe, or rather it's our position, that in relation to the gang rape of the witness 75, Dragan Zelenović is responsible for this gang rape, although he himself did not rape that victim, because he and Gojko Janković together started. It's a one event, the gang rape of 75, and Dragan Zelenović is involved in that as he is, together with Gojko Janković, interrogating the woman and then turning her over to the rapists. This is his responsibility in relation to the witness 75.
Yes, so I now do understand that although he did not himself committed a rape as described in further detail in 5.4, yes, you keep him responsible under 5.3, individually responsible, yes, for his role in the gang rape in which he finally physically did not take part, and which is described in 5.4.
Yes, Your Honor, that's how we see it.
At least now it's clear to me exactly how to understand the indictment in this respect, and also may assist the accused in understanding what he'll be pleading to. Then, Mr. Zelenović, may I ask you, you arrived in the detention unit by now. Do you have any complaints about treatment in the detention units or treatment on your way getting there?
Ne, nikak.
No, none at all. Everything is fine.
Thank you. And then another question is whether you have any concerns about your own health. If you would like to, if you'd prefer to answer that question not in public, please ask me. Then we'll turn into private session so that only we will hear any concerns you may raise. But it's up to you. For example, if you have no real health concerns, then it might be needed.
Yes, yes.
Is there anything you'd like to say about your health which I should know? Please, you have an opportunity to do so.
Ne, nema ništa.
No, nothing at all.
Is there anything else you'd like to raise, so apart from what I raised, health, treatment, is there anything else you'd like to bring to my attention prior to the next hearing, which will be scheduled within the next 30 days?
Ne, ne, ne.
No, no.
Mr. van der Spoel, any matter you'd like to raise?
Thank you, Your Honor.
Madam South.
No, thank you, Honor.
Then, Mr. Zelenović, this concludes your initial appearance. A new hearing will be scheduled in which you'll be invited to enter a plea, a guilty plea or a non-guilty plea. We stand adjourned.
All rise. Veuillez vous lever.